I'm Dave Williams, and I'm the managing partner at Harrison Pensa.
My name's Barb Legate, and I am the senior lawyer with Legate and Associates. To this day, we know that Roche cannot tell us how it actually works, but it continues to be prescribed in Canada for acne. It is no longer prescribed in the United States for acne. Roche, on their own website and their materials, would tell us that that's because of lawsuits. Accutane is a very, very powerful drug, and it can affect people in a multitude of ways. This lawsuit in particular is about the effect that Accutane has on one's digestive system. And in particular, it can cause IBD, inflammatory bowel disease.
The focus of the lawsuit is on the warnings and disclosure that was given by the manufacturer of Accutane to the physicians and then on to the patients when they were considering taking the drug. Mainly taken for the treatment of very serious acne conditions, only the most serious of which where all other treatments failed. And our concern and the concern in the lawsuit is that proper disclosure and warnings weren't given to the patients. The result was they developed inflammatory bowel disease, which is a very serious, lifelong condition, has a number of implications, changes people's lives materially, causes significant injury and damage to them. As I said, the focus of the claim against the manufacturer has to do with appropriate disclosure and warning, and that's important because people rely on their doctors to have that information and then to pass it on to them. This is private litigation, but there's an important public issue. Companies should be held accountable for making full, complete disclosure of the implications of taking the drug. That didn't occur here in our view, and we intend to prove that. It's the kind of condition one would never want to risk having. And that's our concern, is that people risked having it without understanding they were risking having it. The mass tort is simply a series of individual lawsuits that are brought against a common defendant, in this case the manufacturer, with a common theme to them, in this case concerns about the disclosure, adequate disclosure and warnings. On the damage sides of the lawsuit, obviously each individual's claim is different. We're learning that as we speak to people. Some people have very, very considerable and great health problems as a result of it. It's not uncommon for law firms, when they have a mutual interest for clients in a matter, to join resources, complementary skill sets to bring a case, and that's happened here. We think there's strength in the combination of the two firms. We know each other well and respect one another. We think we're stronger, the two of us, than we are individually. This is a complex piece of litigation. We don't underestimate it, but we think we have the right team in place in the two law firms to address the client's needs.
We are here to attempt to redress the power imbalance that comes when you are pursuing a claim against a large, powerful, and well-funded organization such as Roche. We think that by combining our resources, we're well placed to do that. This lawsuit is about accountability of a very wealthy and powerful company to the users of its product. What if this product was known to be harmful? And what if it was impossible for the user of the product to know about the harm that could befall them? That's why this lawsuit is important. It's to shine a light on these powerful companies that don't adequately warn individuals about the risks they are taking when they choose to take those drugs.
We've tried to make the process pretty easy through our communications material and through essentially our websites, joint website, and we have a staff on standby to take people's calls and inquiries, and we'll be able to then speak with them and figure out whether they've got a problem that we can assist them with. We think we can.